All right, 5 people arrested during the protests in Ferguson, Missouri have filed a $40 million lawsuit against police. The suit alleges police used excessive force and made unnecessary arrests during the protests in the days after Michael Brown was shot and killed by an officer. The lawsuit lists Ferguson Police Chief Thomas Jackson, St. Louis County Chief John Belmar, and several unnamed officers. Also listed as defendants are the city and county governments. One plaintiff says she was arrested with her 17-year-old son while in a McDonald's. Another says he was just trying to visit his mother when he was shot with rubber bullets and beaten by police. This suit was not filed by Michael Brown's family, just protesters who were arrested after the shooting. Let's bring in our legal guys, Avery Freeman, a civil rights attorney and law professor in Cleveland. Good to see you.
Hi, Frederica.
And New York criminal defense attorney Richard Herman, and law professor joining us from, this time Los Angeles. You're all over the place, you guys. Good to see you.
Hey, it's been a long time, Fred.
I was going to say, I feel like it's been way too long.
Way too long, right.
Oh, man, we got to stop that. Okay, so Avery, you first on this. Does this lawsuit kind of meet the standards of a successful federal suit?
Well, barely. Here's the problem. There was such a rush to get this case filed that the lawyers for the plaintiffs, in my opinion, missed all the major claims under the Constitution of the United States. Missed them all. Missed the First Amendment claim, missed the due process claim. It's not in there. The case was rushed to federal district court, and on top of it, the civil plaintiffs are all criminal defendants. And ordinarily, in federal civil rights practice, you get the criminal case out of the way, then you file it. So, given the sobriety and the seriousness of what went on in Ferguson, it was right to file the case, but the lawyers have a lot of work to do in cleaning the mess up that they got filed, and they have a right to amend. They need, like the NAACP or ACLU backing them up, get some responsible, experienced lawyers in there.
So then, Richard, if you agree with that, is it too late to amend? Does it make it messy to amend or even incorporate other attorneys at this point?
It's not too late. It's not too late, Fred, and messiness is not really like a legal term here, so they can
That's
absolutely.
my term. The non-legal mind here.
Yeah, I like that. Yeah. I like your term. It's more apropos. But no, Fred, I looked at the complaint, I studied it. In my opinion, I think a couple of the causes of action are going to be summarily dismissed. And Avery makes a point that these are criminal defendants. Now they, in turn, bring a civil litigation. That means that their Fifth Amendment rights are down the drain. They're going to be deposed in the civil case that's going to lay the foundation for criminal convictions for them. And, anybody can file a complaint. You get an index number. You can make all the allegations you want.
And you're saying they're criminal defendants because they were, arrested, apprehended, and even though this lawsuit is claiming that they were, it was a mistake that they were apprehended, that they were innocent, they still have the charges imposed against them, and so it makes it very difficult to move forward to involve them in this now federal case.
Well,
back to the non-legal speak. That's me talking.
One of the plaintiffs said she was at McDonald's, and she was arrested for failure to disperse, told to shut up, and she has an $11 million lawsuit. That actually isn't a particularly responsible way of bringing a very serious civil rights case, Frederica. You don't do it that way.
Okay, so then how
Fred, if you read the complaint, Fred, if you read the complaint, it's like, these are near riot conditions going on, and people are taking a lovely stroll down the street, and all of a sudden they're told to move, and they ask why, and they get arrested. And they get shot with rubber bullets. The facts are going to be severely different than what's alleged in the complaint here, I think. But again, I think some of the causes of action immediately will be dismissed.
Well, isn't it the case that, or at least in many jurisdictions, it's nearly impossible to sue a city? And in this case, it is, the suit is being imposed against the city, city leaders and county leaders. Does that already create an obstacle, Avery, for any lawsuit, even if it was spelled out as you put it, where there were real constitutional rights that were violated here? Aside from that, does it make it nearly impossible to sue a state or city or local government?
Well, in terms of punitive damage claims, the U.S. Supreme Court, Frederica, said in 1981, that's 33 years ago, that you can't get punitive damages off the city of Ferguson or St. Louis County. The lawsuit asks for that. So in respect to the viability of the claim, that goes right out the window. And the answer to your question is absolutely. Because of the Newport Facts decision back in 1981, it makes it very difficult to recover substantial damages off of municipalities.
All right, last word.
Fred,
on that
Fred,
one?
Fred.
Yes, Richard.
Fred, as a general rule, there is sovereign immunity. However, there are so many exceptions to this rule, and there's a flood of litigation against municipalities and cities and states. So there is a lot of litigation in this area, Fred. They could be found liable. They could get hit for substantial damages here. Will it happen? We'll see how this thing unfolds.
Okay, well, you know, it's been a while since we've all had a chance to talk, so that's why we're not going to let you go just yet. We've got another case that we want to tackle, so to speak, with you all, this involving the NFL
Yeah,
as football season gets underway. We'll talk about that right after this.